Hi everyone, and thank you for joining us for today's webinar. My name's Carly Hanson. I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. Today's webinar topic is Risk and Practice Management when working from home, presented by Hopgood Gannon Lawyers for us. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. The CLCQ office is based in Meanjin, Brisbane, and so I'd like to acknowledge the Turrbal and Yagara people. I'd like to pay respect to their elders, past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and across the country, I'd also like to pay respect to the traditional owners throughout Australia and extend a very warm welcome to any First Nations people who are listening in today. So as I mentioned, we've got some fantastic presenters from Hopgood Gannon with us today, John Urbacher, Senior Associate, and Evan Dixon, Associate. And they'll take us through a bit of a reminder of our professional obligations pursuant to the Australian Solicitors Conduct Rules and provide some pre-COVID examples where practitioners have been found to be in breach of these obligations. As we know, the COVID global pandemic has resulted in many legal practitioners working from home, which can present challenges regarding compliance with the Australian Solicitors Conduct Rules. So John and Evan will talk us through some of the challenges faced by legal practitioners when working from home and how we can ensure compliance with those obligations. So I might, before I hand over to John and Evan, just take us through some quick housekeeping. So today's webinar is being recorded and we'll have the recording available for you to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered this morning, and they're also available for you to download from the handout section of the GoToWebinar control panel on your screen. We do encourage you to ask questions, of course. Please pop those into the question box on the control panel. We'll take those questions at the end of the session, but feel free to type them in as you think of them. And we'll also have quite a number of polls today with some very interesting and topical scenarios. So I really encourage you to participate in those polls as it will help cement that learning for you. So without further ado, I'll now hand over to John and Evan to start the presentation. Thank you so much, John and Evan.
Thanks very much, Carly. Now we'll launch straight into it. Prior to 2020, it wasn't completely uncommon for lawyers and support staff to be working remotely or from home. But since the onset of the pandemic in early 2020, working from home has become the norm, and at least periodically during lockdowns and the like. And realistically, this is likely to continue for most people in some format, even after the pandemic has eased. And finally, our somewhat conservative profession is adapting to a more flexible workplace, and we're also seeing the benefits of it that can be realised in terms of both productivity and employee satisfaction. But law firms and indeed lawyers need to make sure that they're ticking all of the boxes in terms of ensuring they comply with professional obligations and are implementing appropriate risk management strategies. Working from home presents certain challenges when it comes to upholding our professional and ethical obligations, and this means it's critical for us to understand our obligations and how to navigate the issues when they arise. So today we'll briefly run through a reminder of the purpose and effect of Australian Solicitors Conduct Rules, as well as some of the fundamental rules that govern how we need to behave on a daily basis as members of the profession. We won't be doing a comprehensive review of each and every conduct rule, but we will focus on those which are particularly relevant to working from home. Then we'll discuss some challenges associated with working from home using some practical examples, talk about how we as legal practitioners can ensure that we continue to comply with our obligations, and then finally we'll have a pop quiz at the end. And with any luck, you'll come out of today's seminar having had a bit of a refresher on our duties as lawyers, raising your awareness to potential issues when working from home, and hopefully preventing you from falling into any traps.
The Australian Solicitors Conduct Rules were developed by the Law Council and its constituent bodies, including the QLS, in 2012 as a single uniform set of professional conduct rules to be adopted by and for each state and territory within Australia. Their adoption in all jurisdictions means that all of Australia's solicitors are bound by a common set of conduct rules when dealing with clients, the court, and their fellow practitioners, regulators, and others with whom they have a professional relationship. The purpose of these rules is to assist solicitors to act ethically and in accordance with the principles of professional conduct established by the common law and these rules. In considering whether a solicitor has engaged in unsatisfactory professional conduct or professional misconduct, the rules apply in addition to the common law. A breach of these rules is capable of constituting an unsatisfactory professional conduct or professional misconduct and may give rise to disciplinary action by the relevant regulatory authority that cannot be enforced by a third party. On the slide, you can see that as lawyers, our paramount duty is to the court and the administration of justice, and that duty prevails over all other duties. Other fundamental duties include acting in the best interests of a client in any matter in which the solicitor represents the client, being honest and courteous in all dealings in the course of legal practice, the delivery of legal services competently, diligently, and as promptly and reasonably as possible, avoidance of any compromise to integrity and professional independence, and compliance with these rules and also the law. The standard of conduct for legal practitioners is set out in Rule 5 of the ASCR. That rule provides that a solicitor must not engage in conduct which is dishonest or disreputable, or which would demonstrate that a practitioner is not a fit and proper person to practice law, or diminish the public confidence in the administration of justice, or bring the profession into disrepute. This is obviously a very broad and overarching rule which could apply in many scenarios. At common law, in equity and under the ASCR, we owe a duty of confidentiality to our clients and must preserve the confidentiality of information. The duty of confidentiality arises from the fiduciary nature of the relationship between a lawyer and our clients, and will last as long as the information retains its confidential quality. The essence of the rule is that we must never disclose to any person any information which is confidential to a client and acquired by us unless the client authorises the disclosure, or we are permitted or compelled by law to disclose, or we are otherwise permitted by Rule 9.2 of the ASCR. There are limited circumstances where a lawyer can disclose confidential client information as provided in Rule 9.2, being where the client expressly or impliedly authorises disclosure, the solicitor is permitted or is compelled by law to disclose, the solicitor discloses the information in a confidential setting for the sole purpose of obtaining advice in connection with the solicitor's legal or ethical obligations. The solicitor discloses the information for the sole purpose of avoiding the probable commission of a serious criminal offence. The solicitor discloses the information for the purpose of preventing imminent serious physical harm to the client or to another person, or the information is disclosed to the insurer of the solicitor, law practice, or associated entities. Rule 18.1 is in relation to formality before the court. This is an important rule to note in terms of our dealings with the court. Just because we are not standing in a courtroom does not mean that our dealings with the court should be any less formal. And certainly we should never deal with the court with personal familiarity so as to give the appearance that we have special favour with the court. Rule 30.1 of the ASCR provides the solicitor must not take unfair advantage of the obvious error of another solicitor or other person, if to do so would obtain for a client a benefit which has no supportable foundation in law or fact. When a situation arises where there is an obvious error, there is an ethical responsibility upon us to disclose to the other solicitor the error they or the other person has made. Our duty to represent our client is not unlimited. The client does not have the right in the situation to take advantage of the obvious error to obtain a benefit which has no supportable foundation in law. Related to Rule 30.1 is 31.1 regarding inadvertent disclosure. Upon receipt of material suspected that was inadvertently disclosed, the recipient must not use the material, must return, destroy, or delete the material immediately and notify the sender of the steps taken to prevent disclosure. Rule 32.1 provides that a solicitor must not make an allegation against another Australian legal practitioner of unsatisfactory professional conduct or professional misconduct unless the allegation is made bona fide and the solicitor believes on reasonable grounds that the available material by which the allegation could be supported provides a proper basis for it. Rule 37.1 provides that a solicitor with designated responsibility for a matter must exercise reasonable supervision over solicitors and all other employees engaged in the profession of legal services for that matter. Confidentiality is not the same as client legal privilege. Privileged communications will be confidential, but not all confidential information communicated to us as lawyers will be privileged. Client legal privilege is a substantive right that our client is entitled to. Client legal privilege is directed to encouraging a client to make full and frank disclosure to us and thereby enhancing our relationship with the client. It fosters trust and effective representation. The duty of confidence is one of the most important duties we owe to a client and belongs to the client, not to the lawyer. A breach of the duty of confidence can have adverse consequences for us. A client may be entitled to seek damages for its breach, or we may be exposed to disciplinary proceedings. It is the right that our client has to resist the disclosure of confidential information, whether in a document, oral, or in some other form. That is brought into existence for the dominant purpose of giving or obtaining legal advice for the use in existing or anticipated litigation. You can see the two limbs of legal client privilege being advice privilege for communications made for the dominant purpose of the lawyer providing legal advice, and litigation privilege, which relates to communications and documents made for the dominant purpose of use in existing or anticipated legal proceedings. Only the client may waive privilege, which can be either express or implied. For implied waiver, the main question is whether the client has acted inconsistently with the maintenance of that privilege. The test is whether the privilege holder has acted in a way that is plainly inconsistent with the maintaining of confidentiality, such that it manifests an objective intention to abandon the privilege.
So as lawyers, we have to be conscious of how we maintain confidentiality for clients. So this is the first challenge that we're going to have a look at. The duty of confidentiality exists at all times. And just because you're a lawyer these days and you might be working from home or from a coffee shop, or if you're lucky enough from the beach, it doesn't diminish the duty. So considerations need to be see your computer, who can see your paperwork, who can overhear your conversations. While many law firms have gone paperless these days, realistically, we will always have to deal with some form of paper, if only because you work for an old school client who delivers bundles of documents or boxes of documents to your office, or whether some of the practitioners that you might work for like to print everything off before they read them. But however you manage your practice, you need to ensure that confidential information is kept secure. So whether you're working at your kitchen table or you're able to designate an entire room of your house as your office, you should protect your physical files like you would your most precious valuables. So this also goes for transporting documents between your office and your home. Files need to be secure, ideally in a lockable briefcase or suitcase, and if you can, transport them via private modes of transport rather than on public transport. But if you are travelling by public transport, be careful to ensure that the covers of files and things aren't within the view of others on that mode of transport. At home, a sturdy lockable filing cabinet might do the trick if your work area is used by others as well. Alternatively, you might consider putting a separate lock on the door to your home office if you have sole use of that area. In terms of electronic files, securing client information that you store digitally is another concern. Ensuring that your computer screen is locked when you leave the room is good practice. Monitoring voice levels when you're in close proximity to spouses, housemates and neighbours is also important. Make sure your phone doesn't show you details of messages and emails from clients when it's on the lock screen and you might not be attending to it. In the digital world in which we now live, protection against data breaches is also another issue that we need to keep in mind. So using things like encryption and password protection on any laptops and desktop computers and smartphones and the like, using an encrypted email service, maintaining password protection on your Wi-Fi network, and regularly updating your operating systems. These are all ways that we can ensure against data breaches. And what about video conferencing? In the absence of in-person hearings and client meetings, the use of video conferencing technology has seen a massive growth over the past couple of years. So services like Zoom can offer a relatively easy way to keep in contact with clients or even to conduct new client interviews, but they bring their own cybersecurity concerns. So you should always look to use a video conferencing service that provides end-to-end encryption.
Cybersecurity risks are ever present, and working remotely can increase the likelihood of cyber criminals gaining access to your systems and/or files. Cybersecurity is not just an IT issue, it is an essential part of today's legal practice, and everyone in your organisation has a critical role in preventing cybercrime. There is no silver bullet to protect your organisation and clients' money. The concept of cybersecurity must be built into everything people do in a law firm and law organisation. In a recent case involving identity theft, $110,000 was stolen from a Victorian law firm's trust account despite multi-factor authentication being implemented to access online banking and to transact from the account. This case is an important reminder for practitioners to be vigilant, stay informed about the changing nature of cyber threats, and regularly review cyber security practices and procedures. Great IT support to ensure systems are protections are up to date. Staff training and auditing again set the standard. Work issued devices that are not for private use or used by others such as family is preferable. A quality practice management system is part of this overall approach. Multi-factor authentication can help prevent cyber criminals from getting into your email systems and sending false emails or accessing your files. Multi-factor authentication should be enabled as an additional layer of security. In addition to multi-factor authentication, there are some other basic cybersecurity measures you can take, which include ensuring staff passwords are sufficiently strong, never opening unknown or suspicious attachments in links or emails, not using public Wi-Fi for work purposes, always verifying payment details via telephone before transferring any funds in accordance with your organisation policy, be alert to anything unusual or suspicious and check it appropriately, adhering to the firm's policies and procedures about cybersecurity, maintaining up-to-date software on your devices, and educating staff in relation to cyber risks. Cybersecurity risks are constantly evolving, and protecting your organisation's network and data requires vigilance. If you do work with hard copy files, put protocols in place for how they are to be handled, such as scanning a copy of any documents being taken from the office by staff, so that you have a backup copy, and give guidance on how to protect files outside the office, including not leaving files in a car unattended.
Lawyers have professional obligations in relation to the supervision of their employees, as Evan noted earlier. And a failure to supervise an employee solicitor or even a staff member assisting with legal work who is not a solicitor can result in a breach of the rules and, depending on the severity, disciplinary action. So while it's not a new concept, doing it effectively from home is a challenge. Ways that you can ensure that you are supervising staff in compliance with your professional and ethical duties include regular communication, setting a supervision plan out clearly, setting out what's required to be reviewed before it's sent to clients or sent externally, how it will be reviewed, when you'll have catch-ups with staff members to discuss matters, ensuring that staff are trained on systems to ensure that document production is done correctly, and documents are filed appropriately, client confidentiality is maintained. Don't underestimate the value of having a personal conversation as well. So you can try using video conference for catch-ups as opposed to sending an email or making a phone call. The ability to see someone and engage with them can be extremely powerful. So we also need to keep an eye on the mental health of staff. A lawyer who feels disconnected or is unable to engage whilst working from home can quickly become a serious liability if, for example, a limitation date is missed, an important issue is not addressed in an advice, or the lawyer simply struggles to communicate effectively with clients through electronic means. Finally, remember to engage in social contact as well as professional contact. So without that idle chit-chat in the tea room, catch up over lunch or general office banter, work from home life can become monotonous and isolating at times. Record keeping is another important part of the duty to be competent and diligent. For example, keeping a written record of each phone call and meeting of substance that you might have. It's equally important to ensure that all emails and SMS messages and the like make it onto the file. So how can we address this? Using one of the big dictation software like BigHand and those sorts of things, that you can use those on your mobile phone, so you can do that wherever you might be. That's a good way to be able to ensure that your diary notes are taken down and put onto a file. And remember that the longer the time between the phone call and the conversation and the making of the file note, the less you might remember. In terms of electronic filing, using software that facilitates the filing of various different types of documents, including SMS, texts and emails, can ensure that accurate records are kept and all written records are filed away.
The use of smartphones for work purposes has been a game changer in terms of creating an agile and flexible workplace. Without them, one wonders how we would have coped through the global pandemic and the sudden need to work from a place other than the office. They allow people to speak, read and send written communications on the go, but is this safe practice? We need to keep in mind that when we are not at our desk, we are often more easily distracted, and if you're enjoying the flexibility of working from home and perhaps taking the dog for a quick 20-minute break after lunch, what do you do when you receive a call on your mobile from a client? Will the client have your full attention? The client may ask you to action something. Will you remember to follow up the task? Can you read an email properly off the small screen? Other risks present themselves with sending emails to the wrong email address. Plus, you can't file an email from your phone, so there's double handling, which is also not great time management. Personally, there have been many a time when I've read an email quickly on my phone, then realised I misunderstood the meaning when I read it again later on my laptop. Plus, it's also easy to miss attachments. What can we do to limit the risks associated with using mobile phones whilst working from home? Set your phone to divert to voicemail when going on breaks. Don't answer work calls whilst not working or distracted, e.g. walking the dog, driving the car, picking up the kids. Consider having 2 mobile phones, one for work and one for personal use, and also increase the font size on your screen so you can read emails and messages properly.
So there is a level of informality that seems to have come from working from home, and whether it's your work attire, the background for your video conferencing, dealing with interruptions from your surrounds or otherwise, everyone seems to relax a little bit from work when they're working from home. One of the many beauties, in my view at least, of working from home is that you gain an hour or 2 in the day, depending on how long your commute is. And it's not just the commute, it's because you may not need to spend the time getting yourself ready for the day that you would otherwise do if you were preparing to be in the office. I think we've all been guilty of spending a day or 2 working from home in our pajamas, or at least our favourite daggy old t-shirt. It's important, however, to ensure that you do dress for the occasion. If you have video conferences scheduled for the day, ensure that you are attired as if you were attending meetings in the office. Similarly, you might be in a meeting, be meeting with a client or a colleague at a cafe. being a mutually convenient meeting place. Just because it's your favourite cafe and you might frequent that cafe on weekends in your favourite t-shirt and boardies and a pair of thongs doesn't mean that you can adopt the same approach for a work meeting. If you're appearing in court by video link, you need to ensure that your attire complies with accepted dress requirements for court appearances. Moreover, remember that a solicitor's duty to the court and to the administration of justice is paramount, regardless of whether the solicitor is appearing in person in the courtroom or appearing remotely. So there is no relaxation of this paramount duty simply because the method of appearance before the court has changed. The QLS has issued guidance notes regarding appearances in court by video link, and you should all have a look at that. I won't go through the detail of it, but it explains the expectations of how a solicitor is to comply with his or her duty when appearing in court remotely. In terms of video conferencing generally, it might be appropriate to set your background display or blur the background in order to give a professional impression rather than showing background photos of a family vacation or the toaster or the TV or whatever it might be in the backdrop. Also, be conscious of interruptions, whether by kids or a barking dog or other background noise. While we've all learned to tolerate various interruptions as we come to grips with the changes of working from home, it is important to ensure that you remain as professional a demeanour as you would if you were in the office. So if there are kids or other family members at home, let them know that you'll be on a call or video conference for a certain period of time and that they should not interrupt you because they are hungry or because their sister is being mean to them or whatever it might be. I'm sure we all recall the videos that have gone viral of unsuspecting spouses passing by in a towel or less in the background whilst a video conference is ongoing. Keep your video conferences to one designated location to avoid any uncertainty as to whether you are or are not on call.
So the final note of caution we have for you today is about taking care of yourself while you adjust to a work from home environment. On top of all the personal reasons, you should be devoting some of your time to focus on self-care. You cannot take care of your clients if you're not taking care of yourself. People who work in an office or anywhere outside of the home really have a clear dividing line between work and home. When they leave the office and go home, they are no longer at work. As obvious as it sounds, working from home throws the entire concept into disarray, sometimes in unexpected ways. As mentioned, try to set up a dedicated workspace within your home as best you can. Use that space solely for work and nothing else. Perhaps more importantly, do not use other parts of your home for work whenever possible. Be at work when you are working and at home when you're off the clock. If keeping strict working hours work for you, try to stick to that system. Some people do best when held to a 9-to-5 schedule, while others don't. Working from home may provide flexibility to your schedule, except perhaps where specific organisation requirements, client meetings and court hearings are concerned. Just remember when you're at work and when you are not. That's enough theory for now, so we're going to swing into some practical examples where we get to test how well you've been listening. So we'll be doing this via a pop quiz, and I believe you'll be able to vote. It's a multiple choice, so we'll be popping up the pop quiz very shortly. So the first scenario we have on the screen there is you act in a matter currently before the Supreme Court. Unfortunately, your client has been diagnosed with COVID and is isolating at home. Pursuant to orders of the court, your client is required to file an affidavit today. You have briefed counsel who have prepared the affidavit. You have read it and forwarded it on to your client. You request that they closely read the affidavit and make any amendments as required. Around 30 minutes later, your client calls and says they have read the draft affidavit, made some minor amendments, and has the final version in front of them. They want to swear the content of the affidavit are true and correct. Your client confirms they have a Bible and reads the content of the affidavit over the phone. You then ask your client to confirm they have the hand on the Bible and then ask, do you swear the content of this affidavit in front of you to be true and correct and to the best of your knowledge, information and beliefs, so help you God? Your client replies saying words to the effect of yes and I do. The client then signs the affidavit and emails a copy to you. You then insert your signature as the witness of the affidavit. So what issues have arisen here? We have A, none. Your client was in isolation and therefore could not come into your office for you to witness their affidavit. Therefore, you can witness the affidavit over the phone. None, your professional obligations only apply when reasonable and necessary. Given there is a pandemic going on, there is some leniency afforded to legal practitioners. C, you have engaged in unsatisfactory professional conduct by not witnessing the affidavit of your client correctly. Or D, none, you have complied with your duty to your client to make life as convenient as possible for them in difficult pandemic times.
Thanks, John and Evan. Carly here again. I've just launched the poll, so you should see that up on your screen. So just select the answer based on those 4 options, A, B, C or D. If you can't see the questions and answer responses anymore, you can get that from the handouts and download the PowerPoint if you don't have it in front of you. I'll just leave it open for another 15 or 20 seconds. Got our votes. Votes are coming in, which is looking good. Lots of people voting for C and a few votes for A and B and also for D. So go 10 more seconds on that one. All right, and I'll close that poll up now. Thanks everyone for your participation. Now the results that have come in, we've got 73% people have voted for C, 15% for B, 8% for A and 3% for D. And back to John and Evan now.
Okay, the answer here is actually C. So 73% correct. You have engaged in unsatisfactory professional conduct by not witnessing the affidavit of your client correctly. The Rule 432 of the Uniform Civil Procedure Rules makes it clear that an affidavit must be signed by the person making it in the presence of the person authorised to take the affidavit. In Legal Services and Bentley, a solicitor, Mr. Bentley, purported to witness the signature of a client on an affidavit filed in the Supreme Court in circumstances where the execution of the affidavit did not take place in the presence of Mr. Bentley. The client telephoned Mr. Bentley from overseas and told him that he had read the draft affidavit, made some changes, that the final version was in front of him, and then proceeded to swear the affidavit and the contents were true and correct. Mr. Bentley then witnessed the affidavit and consequently was found to have engaged in unsatisfactory professional conduct. Section 12B of the Justice legislation, which was part of the COVID emergency response legislation that was brought in, the Justice legislation regulations provide that the affidavits may now be witnessed by audio visual link, however not by telephone. If the affidavit is witnessed solely via telephone and not audio visual link, then it's likely to be unsatisfactory professional conduct and you may be liable to sanction. However, be wary as these special COVID-related measures can quickly change along with the changing nature of the COVID pandemic, and these emergency response regulations are due to expire on the 30th of April this year.
All right, we'll get into scenario 2. So in this scenario, you're working on a contentious legal matter against a private company, Big Co. You're keen to impress your boss by getting a good outcome, but the case hasn't been going so well. So you're fed up with work for the week, you knock off early on Friday afternoon to have a beer with your friendly neighbour, Jim. And during the course of some small talk, Jim tells you that he actually works for Big Co as its CFO. You tell Jim about the legal case against Big Co and say that you're hoping to settle the case soon as it's becoming a bit of a drain. Being a friendly, chatty type, Jim tells you that he had in fact heard about your case And the company's CEO had told him to put $1 million entry in Bigco's financial forecasts as a contingent liability in order to account for the settlement sum that Bigco thought that it might need to pay to get rid of the matter. The following week, you write to Bigco Solicitors making a without prejudice offer of $1 million, and it's accepted. Your boss is so impressed that you get Employee of the Month and a $50 gift voucher. So, A, B, C or D, what issues have arisen? A, none. ASCR 4 requires you to act in your client's best interests, and when you found out that information that could be used to your client's advantage, you rightly took advantage of it and you got a great result for your client. B, your employer has likely breached the ASCR by paying you a $50 bonus for settling such a good case. C, you've likely breached ASCR 3.1 because you have put your duty to act in your client's interests before your paramount duty to the court and the administration of justice. Or D, you have engaged in conduct that breaches a number of ASCR and you may find yourself in big strife with the LFC. All right, A, B, C or D, the pop quiz should be up, the poll should be open now.
Yes, the poll's open, thank you. So I've got 50% of people have voted so far, so I'll just give you another 10 seconds for those votes to roll in. All right, so I might just shut that poll down now, so get your last votes in, and thanks for that. Okay, closing that poll. So we've got 92% of people have selected D, 6% have selected C, and 2% have selected E.
All right, very good. Well, the answer is D. You could find yourself in big strife here because there's a list a mile long of solicitors' conduct rules that you may well have breached. First is 3.1, which is that you've got a paramount duty to the administration of justice and to the court, which prevails to the extent of any inconsistency with another duty. So just because you saw an opportunity to do well for your client doesn't mean you can forget about your paramount duty. Obviously, Rule 30.1 is another important one where it says that a solicitor shouldn't take or must not take unfair advantage of an error of another person. So by the CFO telling you about that, what it included in the financials, he obviously shouldn't have done that. So arguably that's an error of another person. 31.1 talks about a solicitor to whom material known or reasonably suspected to be confidential is disclosed should notify the other solicitor and return or destroy or delete the material. And then Rule 33.1 also requires that a solicitor must not deal directly with the client or clients of another practitioner. Now, the CFO of a company is obviously an officer of the company and is likely to be construed as a client. The reasoning behind that particular rule is that if permitted direct contact with a client of another practitioner, you might be able to secure damaging admissions or access privileged material, which obviously happened in this case, or undermine the other party's confidence in their lawyer. And you also risk becoming a witness in your own case if there's a dispute about the terms of any communication. All right.
Okay, on to scenario 3. You have been working at home for a few weeks now and are starting to get into the groove of it, often stopping in for a morning coffee at your local cafe, and sometimes even doing a little bit of work on your laptop there. You've struck up quite the rapport with the hipster cafe owner, Davo. After hearing a few of your phone calls to clients, Davo has become aware that you're a lawyer and thinks you must be pretty smart to know all that law and order stuff. One morning, he delivers your skinny latte and says, "This one's on the house. If you can give me a quick bit of legal advice." Davo proceeds to tell you that he's heard of heaps of other cafe owners getting reduced rents because of COVID. He said his cafe has been going great guns fortunately, but his landlord was being a bit tight and wouldn't give him a rent holiday. He asked you what he should do. You're a family lawyer, but did a rotation through the firm's property section and remember a thing or two about leases, and have read the news headlines about the federal government bringing in laws surrounding commercial and retail leases which give tenants a bit of a rent holiday. You tell Davo he should just stop paying his rent for the time being, as any rent or rent to commercial tenancies basically can't be enforced against the tenant whilst COVID is ongoing. So here again, we've got A, B, C or D. Option A, none. You gave Davo reasonable off-the-cuff advice. He ended up getting a rent holiday from his landlord anyway. No harm, no foul. B, you breached your professional ethical obligations by not issuing a client agreement to him before providing legal advice. C, you have breached your professional ethical obligations because you did not know the area of law but professed to give advice, albeit informal. Or D, none, it was just a casual conversation and you're not providing professional legal services, so the ASCR did not apply. If Davo wanted formal legal advice, then he should have engaged you and paid for your time instead of offering you a free coffee. What issues have arisen, A, B, C or D? The poll is now open.
Excellent, and we've got lots of responses coming through already, so I'll give you another 10 seconds for that to come through. All right, just 5 more seconds there. Great, I'll close that poll up now. So fantastic, we had 80% of people saying answer C, 14% selected B, and 3% for both A and D.
Okay, the answer here is B. You have breached one of your fundamental ethical duties. Rule 4.1.3, a solicitor must also deliver legal services competently, diligently, and as promptly as reasonably possible. You've also likely breached Rule 4.1.1, act in the best interest of a client in any matter in which the solicitor represents the client. Even though your advice was informal, your ethical duties are not diminished. On to 4.
All right. Scenario 4. You're appearing in QCAT today in relation to a neighbourhood dispute regarding a problematic tree. Due to COVID, the tribunal has asked everyone to appear via video link. You tidy yourself up, put on your best suit jacket and get ready for the appearance by dialing into the video conferencing platform with plenty of time to spare. You and your opponent are both accepted into the video conference room by the tribunal registrar, who is coordinating the video conference. You note that the tribunal registrar is actually an old friend of yours from law school days. You say hello and ask her how she's been. You then proceed to discuss the good old days and how wild you all used to get down at the Sunday sessions down at the regatta. She wishes you all the best for today's hearing. A few minutes later, the tribunal member arrives and calls on the parties to state their appearances. All right, what issues have arisen? Now we've got A, B, C, D or E on this occasion. A, none. You've complied with your duties to engage with the tribunal registrar in an honest and courteous manner. B, none. You complied with your duties by familiarising yourself with the tribunal's practice direction, preparing yourself for the hearing, dialing in early and wearing suitable attire. C, you've likely breached ASCR 4.1.2, which is your duty to be honest and courteous in all dealings with the court, in the court of legal practice, by speaking about the registrar's social life in front of others, which is in breach of the ASCR, and failing to acknowledge your opponent, who was also waiting in the video conference. Or D, you've likely breached ASCR 18.1 because you had a conversation with the tribunal registrar on terms of informal personal familiarity. Or E, you've likely breached ASCR 18.1 because you had a conversation with the tribunal registrar on terms of informal personal familiarity in the presence of your opponent, which may have given the appearance that you had special favour with the court. A, B, C, D, or E?
Thanks for that. Again, the votes are rolling in quickly, which is awesome. Give you another 10 seconds to pop your response in on the screen. All right, I'll just close down that poll now. Thanks so much. So we've got 83% of people selecting E, 14% selected D, and 3% for C.
Great, 83% are correct. The answer is E. You've likely breached Solicitors Conduct Rule 18.1. Note that the rules specifically apply where you are in the presence of other parties or solicitors, although it would be advisable to always maintain a level of formality with any court officials, particularly when dealing with them in a professional sense.
Okay, we're on to scenario 5. Just prior to COVID, you hired a new law clerk, Sally. Sally has been a superstar from day one, taking witness statements, preparing draft court documents, and preparing lists of documents. Best of all, the clients love her, so you let her do all the liaising with clients. Sally is confident and independent, so you don't need to get too involved in her matters until the real legal work needs to be done. As a result, you only touch base once a week on Monday mornings for a quick chat over a virtual coffee. So what issues have arisen here? We've got A, B, C, or D. A, none. Sally is clearly competent, the clients are happy, and you are keeping a watching brief on her work. B, you have likely breached ASCR Rule 37.1 as you have not been exercising reasonable supervision over Sally in the provision of legal services. C, you have likely breached Rule 4.1 as using a law clerk to do complex legal work such as drafting pleadings is not acting in the best interest of clients. Or D, none, there is no requirement to supervise non-qualified legal staff under the ASCR, and in any event, she is not doing legal work. A, B, C, or D.
Okay, so the votes are coming in once again. I'll leave that one open for another 10 seconds. Pop your response in now. Great, I'll just close that poll up, thank you. So we've got 80% of people have responded as B, 20% as C. Thanks.
Excellent. The answer here is B. Rule 37.1, a solicitor with designated responsibility for a matter must exercise reasonable supervision over solicitors and all other employees engaged in the profession of legal services for the matter. Note that it extends to all employees, not just solicitors.
All right. Scenario 6. You're working on a case for a high-profile client. Your client informs you that he's concerned about some tax issues that he might have in relation to his business, and he's worried that he might have committed some tax offences. You tell him to send you an email with the details, and he does so. You take a quick glance of it, and it all looks like a big old headache. So you duck out to the kitchen to grab a coffee before you get too far into the detail. Your roommate is also working from home. He works for the ATO, and it's 4 p.m, so he's clocked off for the day, and he walks into your room to see what you're up to. He notices on your screen the email that you've just received from your client with a reline, tax offences, please help. Coincidentally, a week later, your client is audited by the ATO. So what issues have arisen? A, none. Your roommate should not have walked into your room and viewed your computer without your authority, and you can't be held in breach of any duty of confidentiality in the circumstances. B, you've likely breached your duty of confidentiality to your client because you failed to delete his email immediately and destroy all evidence of it in circumstances where it revealed all sorts of tax offences. C, you've likely breached your duty of confidentiality to your client because you failed to lock your door or computer screen before going to grab a coffee when you were aware that your roommate works for the ATO. Or D, none. Your client had committed all sorts of tax offences, and as a solicitor, you're able to disclose client confidential information if it relates to the commission of a serious criminal offence, including tax fraud. What do you think?
Looks like people are feeling pretty confident about the right answer here. So I'll just give you another 10 seconds to pop that response into the poll. Great. All right, I'll close that poll off now. Thank you. So it looks like 97% of people have responded with C, and then 2% each for A and B. Maths doesn't quite add up.
Very good. That doesn't quite add up. I noticed that straight away too. But anyway, 97%, well done. The answer here is C. You breached your obligation as to confidentiality under ASCR 9.1. Some of you might have thought that D was correct, and there were a couple of percent there. The relevant provision is ASCR 9.2.4, which enables a solicitor to disclose confidential information for the sole purpose of avoiding the probable commission of a serious criminal offence. Now, in this case, any offence had, on the facts, already been committed, and there's also a question as to whether or not the tax offences in question might constitute a serious criminal offence for the purpose of that rule, and it's probably not in this case.
Okay, we have scenario 7 here. You are enjoying the flexibility of working from home, including the ability to knock off a little earlier than usual on a Friday afternoon in order to collect your kids from school and attend a school fundraiser barbecue. You happen to bump into the solicitor on the other side of a matter and you get talking. The other solicitor is an old school type who fancies himself as a bit of a wheeler and dealer when it comes to negotiating outcomes. Alarm bells are beginning to ring when he asks to speak with you off the record. So what issues have arisen? Can you have an off the record conversation? We've got A, yes, provided you both expressly agree to do so. B, no, there is no such thing as an off the record conversation between two solicitors in the engagement of legal practice. C, no, you should never agree to an off the record conversation, because if the other solicitor says something which compromises their client's position, you want to be able to use that information to your client's advantage in accordance with the duty to act in your client's best interest. Or D, yes, provided that your client has provided you with instructions to agree to the conversation on that basis and you are not using a recording device.
Great, that poll is open and people are voting. Looks pretty neck and neck for this one. So I'll give you another 10 seconds to pop your vote in and we'll see what the correct answer is. Okay, I'll just close up that poll now. Thank you for your votes. So we've actually landed on 50% selected B, 36% have selected C, 13% with D, and 2% for A.
Okay, so 50% here are correct with B. The request for an off-the-record conversation is often heard in practice, especially in litigation. However, a prudent practitioner's response should always be no. This is not because it puts your opponent off balance or confers some vital tactical advantage, but because there is no such thing. The phrase off the record has no meaning as determined by a court or statute, which means it can encompass anything or nothing, and crucially, it can also mean different things to different people. If a practitioner intends to make a concession or an offer of compromise in an effort to resolve a dispute or to narrow the issues in dispute, it is appropriate that any such conversation be expressed to be held on a without prejudice basis. Without prejudice privilege will apply to communications and documents made or created in the course of a genuine negotiations to settle a dispute. The privilege applies to protect parties so they can make reasonable settlement offers or concessions in the context of a civil dispute without fear that the content of their negotiations will be used as evidence or some concession of liability. So if we consider off the record in comparison to without prejudice, they are likely to be regarded as different things by a court of law. That is due to simple logic of if a practitioner seeks to enter without prejudice negotiations, he or she can simply make that request by electing to use a different term. There is a strong presumption that something other than without prejudice negotiations were contemplated by the parties.
That scenario, guys, was taken straight from one of the QLS ethics guidance notes. So it's obviously something that comes up quite often, and it's important to be very clear as to the basis for any conversation that you might have with another party. A couple more scenarios that we'll sneak in if we can. Scenario 8, you act for a seller of a commercial property. When reviewing the draft contract on your phone whilst driving to beat the school pickup rush, you fail to notice that a key clause has been omitted from the contract. After forwarding on the draft by email, the solicitor on the other side responds particularly quickly, within the hour, and with his client's signed copy of the contract, and asks that you arrange for your client to countersign the contract that day. You arrange for your client to sign the contract and then circulate a fully executed copy. After a nice relaxing weekend, Monday morning, you come to notice that the omission in the contract, and you fire off an email to the solicitor on the other side. Dear colleague, I am greatly concerned by the fact that you have attempted to deceive me by trying to have the contract signed up urgently, knowing that clause 7 had been inadvertently left out of the contract. This is a clear breach of Rule 30 of the ASCR, and your dishonest and disreputable conduct in further breach of Rule 5 of the ASCR demonstrates that. Frankly, you're not a fit and proper person to practice in the legal profession, and I'll be referring this to the LSC. All right, what issues have arisen? A, you've breached the ASCR by failing to act in a courteous manner in dealing with the solicitor for the other party. B, you've breached the ASCR by making serious accusations without ensuring that there's a proper basis for those accusations. C, both A and B above. Or D, none. There's clear evidence that the solicitor on the other side was attempting to take advantage of your error, and as a member of the legal profession, you're entitled to take steps to ensure that the other lawyer's conduct is appropriately investigated by the LSC. What do you think?
All right, votes are coming in, so I'll give you again another 10 seconds to pop your response in there. Okay, great. I'll close up that poll now. Thank you. So 80% of people have responded with C. We've got 5% each for B and D and 2% for A. So what's the correct answer?
Correct answer is C. You've likely breached 2 of the ASCR, failing to act in a courteous manner and also making serious accusations without ensuring that there's a proper basis to make those accusations. ASCR 32 highlights the importance of being careful when making assertions about the conduct of other solicitors. Often allegations of unethical behaviour, unsatisfactory professional conduct and the like are made by solicitors, often in the heat of the moment. However, making such assertions where there is no proper basis for doing so can itself amount to a breach of the rules. Also, there was one other potential breach of the ASCR in that scenario, and I don't know if anyone noticed it. In the scenario, the lawyer was driving whilst reviewing the contract and forwarding the email on her phone. So ASCR 4.1.5 requires that solicitors not comply with the rules. Sorry, not only comply with the rules, but of course, as officers of the court, we have a fundamental duty to comply with the law. Whether or not such a breach would result in any disciplinary action being taken against you by the LSC is a question of the community standards and expectations of the profession at any given point in time. All right.
Okay, our final scenario, scenario 9. You are now working from home much more than you were prior to the COVID pandemic. You decide to renovate your house so you have a much more comfortable space to work, and decide to also create a new media room for you to use on Friday night footy parties with your mates. The works have been completed and you are very happy with your new workspace, and even more so, your new media room. You visit your accountant to have him complete your tax return. When providing instructions to your accountant in relation to your work-related expense deductions, you ask your accountant to claim expenses in relation to the costs associated with the fit-out of your new office and as well your new media room. So here, what issues have arisen? A, none. Your tax return is a personal matter which is not associated with your practice as a solicitor, and therefore you haven't breached any of the ASCR rules. B, none. Your accountant says he can ensure there will be no issues as he will characterise it all as a work-related expense. C, you have likely breached the ASR by engaging in dishonest and disreputable conduct. Or D, none. Every lawyer needs a media room to relax, de-stress, and go take a lunch when working from home.
Okay, looking very clear with the answers coming in, although I do really like option D. So I'll give people another 10 seconds to pop their response in for our final poll. Great, all right, I might close up that poll now. Thank you, everyone. It was a landslide victory for option C, 100%.
Oh, 100%. There we go. Yeah, correct. As nice as it would be to be able to claim a media room, unfortunately, we're not able to. You have likely breached the ASCR Rule 5.1 by engaging in dishonest and disreputable conduct, because your media room fit out is obviously not a work-related expense. This conduct, whilst not in the course of your employment as a lawyer, is dishonest and likely to bring the legal profession into disrepute. Your professional obligations don't end when you knock off for the day, they continue throughout your private life. In legal services and Petchler, Mr. Petchler was convicted of a tax offence, which was one of 5 charges the LSC brought. The tribunal held the failure to lodge tax returns amount to a neglect of a statutory duty inconsistent with the standards which the public expect of a legal practitioner and which can reflect poorly on the legal profession. In the circumstances, this conduct falls substantially below the standard of conduct which would be expected of a legal practitioner, and so is to be regarded as professional misconduct. So you can see by this example, the solicitor's behaviour didn't even need to be dishonest, but provides that the conduct is likely, if the conduct is likely to bring the profession into disrepute, then it will likely be a breach of the ASCR. So in summary for today, we had a reminder of our professional obligations pursuant to the ASCR and our client legal privilege obligations. Then we ran through some of the challenges when working from home, including confidentiality concerns, such as sharing a house with limited space, sound travelling between rooms or neighbours, or leaving documents around or on screens, the supervision of junior practitioners, mental health concerns that may be with working from home and also feeling isolated, record keeping practices such as taking file notes and file management, working effectively from a mobile phone, and informalities including attire, video conference backgrounds, interruptions and interactions with clients and colleagues. We then gave you some practical tips to assist you in working from home and complying with the ASCR, including considering who can see your computer and or paperwork and overhear your conversations, ensuring you shred documents when necessary and do not simply put them in the bin, not leaving your computer unlocked when not in use or leaving hard copy files or documents unattended, never opening unknown or suspicious attachments or links in emails, educating staff in relation to cyber risks and adherence to policies and procedures in relation to cyber security, ensuring hard copy files that leave the office are scanned and not left unattended, regular communication between staff, training, video conferencing as opposed to emails or solely calls, and ensuring there is some form of social contact rather than solely professional contact, and also diverting to voicemail or when on breaks, not answering work calls or sending work emails whilst not working, separate mobile phones, one for work and the other for personal use, always remembering that you are still at work, dressing and acting professionally, and using appropriate video conferencing backgrounds, and avoiding interruptions, setting up a work-specific exit area, and sticking to defined work hours.
There you go. Well, that's us, and thank you for your time. Sorry we've gone a little bit over time, but you all did very well in the pop quiz, importantly, and to finish with 100% is yeah, very commendable.
Thanks so much, John and Evan. A really great presentation, and the polls were really well received. I think everyone was getting into them very quickly once people started to get the hang of it. So we will have maybe a few minutes for questions if there are any. So please feel free to type those into the questions box. There have been a couple of other comments that have come throughout the session. So certainly lots of comments saying thank you, really interesting, great fun, really informative, and a great reminder of our professional obligations. Really liked the pop-up quiz component to keep us engaged. Thanks very much. So excellent feedback there. I think there was also a comment just in relation to scenario 2. So I'm wondering whether there would also have been a confidentiality breach. So I think this was perhaps I'll just grab it.
That was a scenario involving the friend, the next door neighbour.
Yeah.
Told. Yeah. So I mean, your obligations of confidentiality apply in respect of your own client's confidentiality, or clients of another practitioner. Yeah. So 33.1. Sorry, 33.1. I think that is the question whether or not you've breached the confidentiality of the other party. Of
Yeah, yeah. I think because you don't know that the neighbour.
Yeah, arguably, yeah. If you come into possession of confidential information of another party, notwithstanding that it's not your clients, you still have at least an equitable obligation not to disclose that confidential information. So yeah, certainly that would be another concern. I think that was one of the matters where there were any number of issues with what you've done, and you're probably going to be in all sorts of problems before the LSC. So you could add that to the list as well.
And also in relation to scenario 3, there was a comment about whether you'd breached your responsibilities by talking to clients in a public cafe. So again, things around confidentiality. So that's the cafe advice.
Yeah, certainly. That was yeah, that's a tricky one, and yeah, it's a type of thing that happens to us pretty often. You know, you're at a barbecue on a weekend and someone asks you a legal question. You've got to be very careful about how you deal with that situation. So yeah, there were a few issues with that scenario, and it's not an uncommon one. So worth keeping in mind your obligations around those informal conversations that might occur.
Fantastic. All right. Well, that's all that's come through. So obviously a very comprehensive session, great scenarios, and thank you to those people who have provided some questions and comments in the chat. So on behalf of everyone who attended today, thank you so much to John and Evan and Hopwood Gannon for your support of the community legal sector and for your great presentation today. I will close the presentation down very shortly, and I'll ask that you do please pop your feedback in the short quiz that will pop up on the screen once you close the session. That really helps us to you know, tailor these webinars and improve them as we go through. And just a quick apology for the sound issues at the beginning of the presentation today. Hopefully we got that all sorted out for you. We'll close it off for today, and thanks again to our presenters and attendees, and we'll see you at our next CLCQ webinar, which is happening tomorrow. Thanks everyone, have a great day.